Oh, I hope.
What's up?
No, I'm just thinking. I'm not sure if we did that extra step in the morning, and I'm really hoping that that was not the case.
What extra step? I mean, we have time.
The start broadcast. Sorry. Like I pulled up the start the Google Hangouts, and then I don't think I clicked start broadcast. So I'm hoping that Emily did.
Yeah, she did. I mean,
Okay, yeah, because we watched it. That's right.
Right. So yeah,
Good.
we're good.
Good.
But I mean, the links. How'd you? Where's the link? I mean, it's okay. Link. Ah. So I can try this. Copy that.
Did you guys get the free lunch too? I heard it was each block.
Right. Fuck it.
Check it.
Yes.
Yeah.
Hey, how are you?
How are you?
Good.
Any other house projects you've been working on lately?
You know what? I got some nice countertops. So I went stainless steel on the countertops. Got a new sink, like a farm sink, and a new faucet.
Yeah.
And I'm just looking into like tearing into my bathroom. It's sunny out now. I just kind of want to plant a garden and do that. So I don't know.
Bathrooms can wait.
Kind of, you know. I mean, I'm trying to like get everything nice, but I mean, when outside in Oregon, you kind of just right.
Well, and the bathroom is inside work, so you can work on it.
It's like a winter thing. I know.
When it rains.
I know.
Well, and the rainy season is not over yet. So
You're right about that. I can
just
probably
take
jump
the
into it.
weekend
You're
and
right.
like
You're right.
then deal with that in like a week or two, and then you'll be done by summer, and then you can spend all your time outside again.
You're right. It wouldn't take long to really get into it. How about you? How you doing?
Pretty good. Finish, all that good stuff.
Right. It's pretty awesome, right?
Yeah,
Exciting.
it is awesome, exciting, overwhelming, stressful,
Right. All that, right?
exhausting. Kind of just like the whole shebang. But no, it's good. It'll be a good thing. I'm excited. to be able to go home. I mean, I enjoy it here, but I just miss being around my family.
Oh, okay.
And so that'll be nice. And there's like way more sunshine in Texas, so
What part of Texas?
Central,
Oh,
just
okay.
outside Austin. I don't know if that's where I'll like actually end up being, but that's like where I grew up. You know, figure out the job thing first, and
Right.
then
No.
we'll decide where. But yeah, I mean, it'll be good to be close and still know that I can like come back and visit and whatnot. And, like I know the right times to come now too.
Right.
So that's
That's
great.
so crucial.
Because I even think I just love fall. Like it's my favorite. And then
Yeah.
like spring once it's like we get like one sunny day in June or not June, February here, and like
Right.
all of the daffodils just like
Boom. I know.
yeah.
I know.
And I remember last year, since it was my first year, being like, no, you might freeze. Don't start
I
it.
know. They come up early and it's like
Don't
poof.
do it. And then
A
they're
hardcore
fine.
weekend.
Yeah.
Right.
So I think that's pretty cool. But you know, so I'll miss that stuff and
Yeah.
trying to take advantage of all the like outdoorsy things here. Like they're just not the same in Texas. Like there's not fields of tulips or
Oh, right. Come on. Right.
you
We
know,
have the ocean here
waterfalls
too.
everywhere.
Right.
The
Right.
ocean, yeah. I haven't done as much like mountain exploring, so maybe I'll try that like at least one weekend, you know.
Cool.
Because that's not the same. We have bluebonnets though, so they're almost as gorgeous as. Let's see if I can find like. I know someone who posted a picture of it, and it looks fake, but like that's what they look like.
Just intense colors.
Well, it's blue, but they're just like fields of it, and it's this like they come out as bluebonnets, and they're called Indian paintbrushes, and they're orange, and they both come up around the same time, and people will literally pull over on the highway and like get out and take pictures, and like
Wow.
kids are like dressed up, like they know they're gonna see them,
Yeah.
and then you just pull over on the side, and so it's just like really funny. He just posted a picture about that.
So you're like going back home a couple weeks?
A couple months, yeah.
Oh,
Like
couple
sometime
months.
in June, yeah. So I have some time to still. Oh my goodness, why is it so far?
I sent you a link.
It didn't come through. It came up as blank email.
Blank.
Yeah. I don't know. Maybe.
I forwarded it. So
Oh, there we go. I'm in just at the end.
right. A long day, long week.
Yeah.
Right.
I saw one of my friends as she was walking by and realized she sent me a text maybe on Wednesday.
Whoops.
And then I realized I have about 5 friends who had sent me texts at some point during this week that I've just looked at and thought I don't have time for this.
Right. Not right now.
Yeah.
Right.
And then you forget about it.
Mhm.
That's what I do too. And then I'm like,
Yeah.
so
So I need to go
Whoops.
through all my own.
Reconnect. Right.
Yeah.
Be a good weekend.
sorry. You really are important to me.
Oh, you beer. Let's go. Let's go drinking.
I'll find it and tell you about it.
Okay. Cool.
Thank you so much.
Hello, everyone. Hello. Hello, YouTube. Today we have the great honor of Michael Z. Green from Texas A&M School of Law. When I found out that Michael Green was coming, I was like, yes! Michael Green, Michael Green is just beloved in the ADR community. He is beloved in the employment law community. And I just can't wait to hear what he has to say. He's obviously very distinguished. He's written dozens of law review articles. He's a constant presence in the media. He has 5 degrees. So he's got a bachelor's degree, a JD, an MBA, an LLM, and a master's degree in labor relations and employee relations. So he's very distinguished. And I'm not going to do all of his credentials justice, other than to say he's just, you know, a wonderful scholar, a wonderful mentor, and we're so, so, so lucky to have him. Thank you for coming.
Thank you for such a lovely introduction. Checks in the mail. I want to start off my presentation by saying that I also have this reputation for doing like PowerPoints where stuff may be flying across the screen every once in a while. And usually over the years, I've gotten about 90% satisfaction rate with that. But every once in a while, I will get someone who will say like, I saw something on the screen and it gave me vertigo, I felt sick. If you feel that sensitivity, I just wanted to warn you ahead of time so that you know you can prepare yourself accordingly. If I see you run out in the middle of the presentation, I will know that it had nothing to do with what I was saying, but what was on the screen at the time. The other warning I give is that I'm also going to be talking about some subjects, which you also know. I mean, we're talking about bias and stuff by its very nature. But I always like to suggest, just out of, you'll see this in my talk about civility, that I will be using one word, and I actually use the euphemism for it, see, the N word. I don't actually use the actual word. And you'll see that also has some implications in some of the discussions about responses to the use of that word. So let me get started. By the way, my intent is to try and go about 45 minutes or so and give you an opportunity to at least have as many questions as possible. If I'm going longer, she's going to run up here and say something wonderful about me again, and you don't want to hear that. So if you have a desire, even while I'm going on, I'm okay with you. If you really need to like get something off your chest, you got to have this answer. I'm okay with that. Okay. She wanted to ask me about the title of my presentation. I'm kind of keeping some things hidden from the Oregon people. So they're like, well, are you going to talk about your paper? It's negotiating blah, blah. That's well, kind of. It's a little part of that. But I'm kind of working on 2 things now. And I thought this was a good opportunity. It kind of fit with the theme of your conference in terms of responses, right? Institutional responses to bias. And so I call it civility and mediation as workplace responses, and to what I call conscious disregard of racially biased behavior. And I call it a tale of 2 theses, because I have 2 separate theses. Eventually I figured out how to join this into one, but as I said, maybe this may end up being 2 actual papers I do, or maybe 1, but I think they're both sufficiently related to what we're talking about today to be helpful in that respect. So that's the plan. But I also want to give you this hypothetical, and I want you to think about this in terms of how all of this relates to everything I'm going to be talking about, and kind of how an institution may respond. And I know from the people who were here earlier, there could be different institutions here, and we could have, and this hypothetical could apply for each one of these particular institutions I'm going to suggest. It could be a private sector workplace. It could be a public sector workplace. And it could also be maybe a public university. All 3 of these will apply to this hypothetical. So first, let's say there's 3 people at a break having a conversation. The first speaker is a Latina female, and she says, I think we need to join together to have some voice, because together we can better present our concerns about the need for better benefits here. Second commenter, A black male responds, I agree. Togetherness and working against the oppressive situation imposed on us. It reminds me of the Black Lives Matter movement, where folks have united to make their voices heard about improper police shootings in our society. And then the third commenter, a white male, responds. And this is his response. He says, F the Black Lives Matter analogy. That is nothing but a bunch of N-word criminals who deserve what they got. This is not about racial gender solidarity, only economic class solidarity. Both of you need to understand that. So this particular conversation could take place in any one of those three settings. It could be in a private workplace where the three of them were actually discussing organizing a union. It could be in a public sector, governmental workplace, where they're possibly also discussing organizing a union. Or it could be graduate students at a public university discussing needed healthcare benefits. You will see in all three scenarios from my presentation that there could be arguments that all of those comments and even the comments from the third commenter are all legally protected statements. And my hope is that when we have these kinds of conversations that take place in these settings, that hopefully I will be able to suggest some institutional responses to them. So that's my hope. So use this hypothetical. It's going to disappear now, I'm sorry, but use this as a way to think about what I'm going to be talking about. When you look at Black worker dispute resolution, and I looked at this more in terms of what's going on for Black workers by the end of the 2015 calendar year. What we see, wages, the median income from result of a report that was done at the end of 2014, looking all the way through 2013, says that Blacks' income is 60% of whites. Unemployment through the end of 2014, 11.3% for Blacks as opposed to 5.3% for whites. And if you go back over the last 42 years, on average, unemployment for Blacks is about twice that of whites. And even in the March 2016 Bureau of Labor Statistics, current unemployment 9% for Blacks as opposed to 4.3% for whites. Incarceration, 1 out of every 3 Black males born today, you can expect to be in jail. Is 6 times more likely to be incarcerated than whites. Life expectancy is 4 years less than whites. And then we add to Black worker despair. There's studies out there that show discrimination still exists in the workplace. There was someone who put a video on earlier, President Obama. He said Johnny versus Jamal. There's an actual study called Christopher and Emily versus Lakeisha and Jamal, where they had the same information used and had people apply for jobs, and the results were racially skewed, where Emily and Christopher got a lot more job opportunities than Lakeisha and Jamal, even with the same information. In Milwaukee, there was a tester study where they sent out 2 individuals with the same backgrounds for entry-level jobs, things like busboy positions. The only difference between the 2, one was Black, the other one was white, and he had a drug conviction. The results were almost exactly the same in terms of the job opportunities they received, suggesting being Black had the burden of also as if you had a criminal drug conviction. Societal issues are going on. I think we have Ferguson and Baltimore and Trayvon Martin, and there's so many others that are going on. I highlighted the Chicago Police Torture Commission, where they were doing a study and they found out that the police had actually been torturing, literally torturing Black defendants for 40 years. They even formed a specific commission to go back and look at wrongful convictions that may have occurred for them. And this has really transformed into these euphemisms of not only driving while black, but looking at Black Lives Matter as institutional responses in terms of activism. Again, with Black worker despair. I just saw yesterday's newspaper. I had to add this. Did you see this in yesterday's USA Today? Chicago Police Accountability Task Force formed by Mayor Rahm Emanuel. 76% of people that were tased were black. 72% of people stopped by police were black. There's only 33% of the Chicago population is black. This task force found this shows that the police have no regard for sanctity of life in Chicago. And in doing so, they surveyed this broad cross-section of people that even includes students and everyday workers. How about the courts for Black worker despair? Claimants lose discrimination cases 90% of the time. Most of the empirical studies show you bring a discrimination claim, 90% of the time you lose. Most of that has been attributed to some judicial hostility to the claims, the burdens of proof, the requirement that you have to show intent most of the time. And then, of course, there's what this conference we talked about in terms of implicit bias. Also, there's some data that show employees have a very difficult time finding lawyers to represent them. That almost 95% of them don't have lawyers in these disputes. And in those rare cases where you win, there's statistical and empirical studies that show a bias even on appeal. That if you are the few situations where you win, you can still lose on appeal. And it's more likely that you will. All of this is about Black worker despair. There have been an increasing number of incidents of nuisance in the workplace and racial incidents and complaints with the EEOC. Race and retaliation are the largest claims that usually get filed with the EEOC every year, although the Americans with Disabilities Act is coming. Pat Chu has a study, Pat Chu from Pittsburgh has a study where she highlighted how the increase in racial harassment incidents were somewhat attributable to President Obama being president. Even though when he was first elected, you had a Gallup poll survey suggest that most people believe that race relations in our country would improve significantly by having a Black president. Then only 4 years later, he even joked. Yeah, that lasted a day. And most of the people who did that same poll 4 years later believe that not only has race relations in our country not improved, but they might have gotten worse. So those who believe that this is a post-racial time period, right, where matters of race don't matter, I suggest we're more in a post-civil rights time period, where there's an ongoing resentment and backlash towards matters of race being raised. So this leads to more despair, where if someone raises a claim of race, others look at it as a zero-sum game. Your need to raise a race claim takes away from me. And so even with implicit bias, I think we're even getting to a point where it's not even about implicit bias anymore. It's about conscious disregard of racial bias, where the mindset is, if you raise race, I don't want to hear it. So we use terms like post-racial and colorblind and call you politically incorrect. Take some responsibility. This is not the 60s. It's not about Black people. It's not about Black Lives Matter. It's about all people matter. So this led me to two theses to kind of address this Black worker despair. My first one, couched in kind of like a disparitist principle. It's not just about race. This is about incivility, bullying. When you don't address complaints that are about racial harassment and you respond in the ways that I just said, like stop the political correctness, this is not about you, stop being so hypersensitive. Doesn't even have to be about race. Any workplace where you refuse to address complaints of your workers, at least incivility, maybe even bullying, and possibly a hostile environment. So these rights-based defenses that keep being brought up, because in my initial scenario, I said that all of the speakers there could argue that their statements were protected, that they had the right to speak and say exactly what they said. But this should have some regulation. These rights defenses should be limited in some way, certainly in accommodating civility. But even under workplace law analysis, employers should have the right to regulate some of this. And with the final discipline being meted out through a special kind of mediation that I'll talk about. So that's my first thesis. It's also something moving up there, so if somebody was worried. Okay, so then my second thesis. We're looking at racial disputes. And most of the time I've been writing about arbitration of discrimination disputes, and there's been so-called mandatory arbitration where you have to arbitrate your claims as a condition of employment. I really came to this conclusion that my next thesis ought to be that mediation gives voice to employees who don't have voice in this kind of anti-backlash, anti-civil rights society that we seem to be developing. And through mediation, if you apply critical race analysis under Derek Bell's interest convergence theory, if you have a diverse crew of mediators who look like, can articulate the interest of the claimants, this will be a way to converge the interest of those concerned about racial disputes, to merge with the interest of employers in having an efficient workplace. A win-win. So those are my two things. So let's talk about what's going on in society right now. I'm going to introduce you to some examples of what I call many rights-based defenses to speech that are going on our campuses and our workplaces right now. Just so you can be familiar with some of the things that I'm trying to get grips with and trying to figure out some way to address them. How did I first get involved in this issue? There are debate about some labor and employment professors. They have this like little works in progress they do every year, like Elizabeth been there before. And there was a group of people discussing something on a blog. And it involved this employee who was a janitor at Indiana University. And it involved a book that he was reading, describing Notre Dame and how Notre Dame, sometime in the 1900s, had been involved in fighting the Ku Klux Klan in South Bend. And there were a lot of complaints about this, and the janitor reading this book at work. Some Black employees had complained. You look at the book, you'll see later that there's some things on it. But again, he asserted his right to have this book read at work, despite the complaints of the Black employees. There was a professor at Kansas, while talking about racial issues on campus, her comment during the classroom session was, she was trying to explain how she herself had not really seen much of the incidents of racism on campus, and referred to, it's not, her statement was something of the nature of, I haven't seen the N-word like spray painted on walls. But she used the actual word. And then, again, there's a First Amendment right to say that. And then there's a civil rights attorney who was speaking at Smith College, and she was talking about efforts to possibly take Huckleberry Finn, which has the N-word all through it, and change it to use the euphemism N-word. And she came to Smith to talk about it. And during her talk, she used the actual word many times. And she said, it's always allowed in an academic setting. And she should always be able to use that word in an academic setting. National Labor Relations Board, they have a doctrine where if you're in the heat of a discussion, they allow certain epithets to be used. There's a case called Cooper Tire. We're doing a union organizing campaign. Some of the workers who are out on strike see some employees coming in who are strike breakers. They're unhappy with them coming in. They start calling them names. And most of them happen to be African American. There's a video. It shows one of them saying the N-word, saying I smell fried chicken and watermelon. And he says he didn't say the N-word, but either way, the National Labor Relations Board said that's protected. It was in the heat of this kind of discussion during the labor organizing act. There's also contractual freedom cases. Widener Law School, where a law professor, Black students complained in his criminal law class because he was using hypotheticals that referred to killing the African American female law dean. They didn't like that. They thought that that was creating a hostile environment. They complained. And he asserted his academic right to freedom for private institutions, basically a contractual based right. There was last year a videotape of an Oklahoma fraternity where students were videotaped making a racist chant. The president responded, talk about that in a little bit, ended up trying to expel the students. But most constitutional rights professors said that was their speech was protected by the First Amendment. Even though in their chant they used the N-word, talked about lynching, things of that. There's a professor who was offered a position at University of Illinois, quit his tenure position, moved there about to start classes, and then 3 weeks before, he ended up having his offer revoked because he had made some very anti-Israel personal tweets. And the University of Illinois felt that they could not tolerate this. He insisted First Amendment rights. Then maybe you heard about what happened at Harvard Law School, where all the African American law professors had black tape placed over their faces. And there was some question whether this is vandalism or free speech. A student activist group called Reclaim Harvard Law had started to take over the student lounge in that area, asking for change. But some of them have argued that this was in response to some student activists that had been complaining about the fact that the Harvard seal refers to someone who was a slave owner, and there had been complaints about removing that, and that student activists had actually placed black tape on the Harvard seal, and that this was the response to that. At Yale, there was a alleged white girls only fraternity party. There was a lecturer who sent an email when there was a suggestion about being respectful during Halloween and how you dress. And she suggested there's nothing wrong with letting kids do stuff offensive and wearing whatever they wanted during Halloween. This ended up having student response to call for her termination, and her husband, who was also a faculty. Now, some of the complaints about this have said, this is basically student reaction that they don't like what they hear. They want to restrict speech. And they want to be coddled. They don't want to hear things they don't like. They try and respond with this activism to try and stop things from being heard. And there have been some incidents where certain schools student groups have tried to stop certain speakers from coming. They didn't want it. But is that coddling, or is it a conscious disregard of the bias that's involved? At Wesleyan University, a student who wrote for the student newspaper wrote a op-ed where he analyzed the Black Lives Matter movement and made several criticisms of it. This led to some student groups asking that the student paper be defunded. In Missouri, at the University of Missouri, there was an incident involving a poop stick. You've heard of that. Someone took their feces and spread it on a bathroom wall, the shape of a swastika. And there were other racial issues there too, right? There was a hunger strike that led to football players boycotting a game, and eventually the resignation of the chancellor and the president, all led by a student group. In Oklahoma, that video chant that I mentioned to you regarding the students on that bus, they ended up being protested by the football team and other students. The president disbanded the fraternity, expelled the 2 students involved. And that video had ultimately been disclosed by a student group called OU Unheard. Now, what should we do? What kind of institutional responses should we make when we have these kinds of incidents that occur? One could be, let's defer to the speaker's comments. Tell those complaining, loosen up. Forget the political correctness. Don't be hypersensitive. And don't even think about asking us for so-called trigger warnings, telling us to be sensitive ahead of time. I guess I did that at the beginning of this presentation. But that's one way. And it's because you value speech. You want to protect the rights of others to comment, whether those comments are liked or not. You won't coddle. In fact, even President Obama said that he's been a little bit concerned about some of the student actions that are taken, especially with trying to stop certain speakers from coming to places. His response was, respond with more speech. Another option, tell the speaker that when the speech is racially offensive, it has no protection. Allow discipline by the speaker in the workplace, maybe through some anti-harassment policy or speech codes or civility or anti-bullying policy. And that's because you ultimately think about it, there are words that can move. It's not about sticks and stones. It's actually about words that can move. And if you're talking about being in a workplace or an institution where people have to work together and get along with each other, what's wrong with the civility of asking that people try not to wound each other or not bully each other? Is there anything wrong with trying to make that happen? Now, I decided those are 2 kind of polar opposites. Is there a more pragmatic option somewhere between these 2 polar opposites? Something that I could suggest that might be better, that kind of looks at both of these issues? What about that civility thing again? How workers have to interact with each other? And they've got to provide services. Doesn't that create motivation for the employer to want to see these issues resolved? And can ADR play a role? Can ADR play a role in these race matters? That's my issue. Now in the private sector, the only way this happens is through the National Labor Relations Act. Sometimes you can argue under the ADA, if people have mental disabilities where they assert that their speech that they utter is protected. Eugene Voloff of UCLA has argued that these restrictions actually violate the First Amendment even in the private sector. And then you have handbooks that might provide contractual rights in the private sector. In the public sector, what are our protections? It's the First Amendment. But the Supreme Court's been pretty clear about what the protections are for balancing this. First, you have to show the speech has some public concern, And then you balance that with the employer's right to efficiency in the workplace. I'm not talking about an employee commenting on their work-related duties, which is the Garcetti case. I'm more talking about like what happened in Rankin versus McPherson, where right after President Reagan was shot, an employee made a comment about that, and that was deemed to be protected. So now, Roe versus City of San Diego, that also helps. There have been a number of cases, mostly in the New York area, where you have public sector employees involved in off-duty activity, but it affects their job responsibility. And even the statements they've been involved in, a lot of the concerns, that's not even a matter of public concern. But even if it is, this balance of the efficiency of the employer to operate their duties is important. So employer efficiency in services allows regulation of employee speech in the First Amendment context. In the private sector, there's so many studies that show rampant rudeness and instability at the workplace and how that has a major cost for employers. If we're thinking about it, then the employer has a major incentive to its bottom line with turnover and other problems to address this. I want to come back to the Keith Sampson example that I told you is what got me involved in this. There's certainly a YouTube video you can watch by an organization that was very supportive of his claims. And if you look at this, the bottom is a picture of the book that he was reading at work. Now, I see crosses in it. I see the Klan highly prominent. And yet, when you looked at this particular situation, most of the public outcry was in his behalf and against an African-American female who complained about this. On this YouTube website, he refers to it as his so-called racial harassment nightmare. He was first told not to read the book because it could be treated like pornography. Then a coworker asked him about it and said that she found it offensive in terms of the KKK. He just kept insisting. It's my right to read a book. You're trying to stop me from reading a book? That's what most of the blogs said too. Political correctness run amok. Somehow this is racial hostile environment to read a book. In fact, the employee is complaining it's inexplicable. And it's a positive message that this book has. So why allow him to not read it? He was eventually disciplined. Again, these bloggers got involved, this organization called FIRE that involved with individual rights and education got involved. Many bloggers, many labor professors I know, all joined in supporting it. I, on the other hand, somehow got on this blog, something I don't really ever do. I got on this blog and started making some comments. And I said, why were the Black workers' reactions to the book, why were they supposedly inexplicable? I didn't see how they were inexplicable. I mean, is there any reason when you go to work as a janitor, you have to be exposed to something that says Ku Klux Klan, something that has white sheets, something that has crosses? If you're there to work, those symbols seem to me they could be offensive. Even the very nature of having a discussion about the subject matter could be offensive. So asking him to not offend his coworkers by reading the book, the real hardship, it wasn't him. He was talking about the hardship that they should just have a little decency, stop political correctness, about having a little civility. Why do you need to read the book? You're a janitor. Why do you need to read this book? But he kept insisting. And others joined in. I was the only one who said, I could see these issues. In fact, the professionals I won't name started contacting me, talking to me personally about this issue, trying to tie up my email. I'm out on Twitter, so they couldn't get me there, or Facebook, or any of that stuff. So they started sending me all these emails. What do you mean? And we started talking about, Randall Kennedy from Harvard has a book, The N-Word. He actually uses the word too. And we got into this example. I said, if I had that book and I'm doing some research, and I'm in my office, and a student, anyone comes in my office, and they see that word, and I can see them starting to cringe or some reaction, I said, I cover up the book. The professor says, well, that's mighty nice of you. But you can't coddle these people. Another professor said to me, a situation they're saying that they were maybe a class on film and the law, and they had it in their syllabus. They're going to show Birth of a Nation. And they had that in there. You should know ahead of time. I said, yeah, I understand. I said, but what if a student comes to you and says, you know, that day you're showing that, it's just going to be too harsh for me. So that's their problem. Really? When I was doing this presentation, a woman came up to me and she said, that reminds me of a situation like, what if that book had been about rape? And maybe the title was called Rape. And this is a story, it's a positive story about how people had helped someone and done all these positive things. Still, if I'd been raped, I wouldn't want to see a book that said rape. And I teach evidence. And I have students come to me sometimes, we cover Rape Shield, and I say, would you please not call on me? I mentioned this to the same professor. That's ridiculous. That infringes on your academic freedom. They can't tell you what to do and who to call in your class and what to talk about. That's a slippery slope. In a little while, you'll be protecting them from everything. Okay? But what about a little civility? What if you can see that they're hurting? You're going to say, it's my right? That's what all this is about, insisting upon my right to say this. Why couldn't these others see this racial incivility? Why? I don't know. So I thought, maybe, it's me. Maybe I'm not seeing it. So I thought about it, and maybe it's about really how employment dispute resolution gets addressed. And if you think about it, it's a system that is based upon filing lawsuits. And I already told you, lawsuits that you're gonna lose. So that's already what the system is about. Then maybe they couldn't understand that. Even these were professors I was talking to who teach employment discrimination. So maybe there's another way. It's gotta be ADR. ADR can do it, right? ADR can save the day. That's why, this is appropriate dispute resolution conference, right? This is the appropriate dispute resolution program at Oregon. ADR can save the day. Well, 25 years ago, we had this landmark thing where Congress changed the Civil Rights Act to allow for jury trials. And surprisingly enough, Supreme Court also decided a decision which allowed employers to require as a condition of employment to arbitrate, the Gilmer decision. So if you go to court, you're gonna lose most of the time. And even those ones who are worried about those few large jury verdicts, well, we'll stop you from even doing that. We'll force you to arbitrate. And now we had 25 years of that. So what do employers think? It was in 2006, I said they're less inclined to use arbitration. And they said it's unpredictable, discovery, all these things they're complaining about. But what it really boiled down to when you get to the end of it, we love mediation. Employers, we love mediation. Okay. All right, you love mediation. So then mediation, negotiation, those are two other forms of ADR, right? That's what's going to solve the day. And the resolution for me is that negotiation, mediation, they don't necessarily solve the day. Lots of commentators have criticized ADR on the basis of prejudice. Now, I had also raised the question that there's been few law review articles in what you might call top tier US News law reviews that discuss this question of bias in ADR. I mean, there were a lot in the 80s. Richard Delgado wrote an article, 1985. Harry Edwards wrote one in 1984. The Trina Grillo article, even though officially 1990, I'll give it the late 80s. But not in any major law reviews have I been able to find articles that are really looking at prejudice in ADR. So I tried to do something about that, putting together a symposium next year where we're going to try and discuss that. But then I said, well, I better write a paper about it. And since I was told I have to talk about this, this will be the last part of what I'm talking about. I wrote a paper called Negotiating While Black. And what I mentioned was this critique of, there are very few top law journals. Yet there's so many studies that tell us that Black persons don't do well in negotiations. Again, there's studies out there, but they were old. Ian Ayers had done several, posted them in major law reviews, but they go back to like the 90s, early 90s. They involve car dealerships. And in his studies, he found that Blacks were offered significantly higher starting offers and final prices than whites. Well, why would that be? Is that just rational thinking? Well, part of it is they just assumed that Black purchasers would have less information. And that might be true, but if you know that and you're doing it, is that a form of implicit bias? Or is it just a conscious disregard of race, racial bias? You purposely said, okay, I'm see a Black person, I'm gonna make them a higher offer. Is that unconscious? You just know because the only thing that you're really worried about, you're saying, I'm not worried about race. The only color I'm worried about is green. It's money. That's the only thing I'm worried about. So is that unconscious or implicit? There have even been more recent lawsuits involving finance, automobile finance. One involving Honda, one involving Ally Finance, where they show purposeful discrimination based on race in automobile finance. And so I said, well, there gotta be some more studies out here, some more critiques. And I found some. There was a real estate closing costs study, 2006. It showed that real estate agents were offering lower closing costs based on race. Ayers did his own study, which he hasn't published, but it's online, looking at eBay. And what he did is he was selling baseball cards, but he had pictures of the cards and the hands of the individuals holding the cards were different based on race. And he used that information and found that there was a disparity based upon race in terms of the offers for those cards. Another study did the same thing, and they took it even further. Goliath and Stein, they decided they were going to start selling iPod Nano. They went through newspaper ads, not eBay. And they put 3 different hands. They had a black hand, a white hand, and a white hand with a tattoo on it. And the black hand didn't get the offers. So that shows race and negotiations again. But is that surprising? Is it surprising? Even when you look at implicit bias and you go do that test, you go to the website, I mean, what really comes out of that is that people tend to prefer people like them, isn't it? Is that such a earth-shattering thing to know? And in fact, maybe it hurts us that we call it implicit, because that feeds into the intent paradigm. That makes it harder for us to have to prove discrimination. Because if we show it's implicit, then we're trying to tell you, and you may feel bad because no one can show you actually intended it. Should we care? Should we care? We know people have biases towards people who tend to be more like them. Outsider groups, people who don't look as much like us, don't tend to have as much information as us when we're the ones who have the power, the money, and are doing the selling. So nothing wrong with assuming that. And in the workplace, I highlight salary negotiations issues. And I use a hypothetical, but there have been some studies, a 2000 study, blacks tend to negotiate less salary. Why? No, is that because of implicit bias from the white negotiators? Or is it a conscious disregard? Does it come back to green again? I know that when I'm negotiating with a black person in the salary, I don't have to be, like I'm relieved. God, I don't have to go through all this stuff I have to go through to get this deal done. And why is that? Okay. In that paper, I talk about this in terms of critical race theory. Stereotype threat. Where people of color, they are trying to deal with the fact that there are certain stereotypes about how they perform. And so that becomes a limit to them in the negotiation process. And in fact, because of those stereotypes, they tend to cover in the workplace and try to hide things and not raise things that can negatively affect the negotiation. In the paper, I discuss these solutions. Provide an equal playing field for information. There's an example of a study about auto retail in terms of internet pricing and how there wasn't race discrimination there. Everybody had the same information. Try and get the white negotiators to consciously seek to minimize these stereotypes. And of course, certainly it'd be great if we had more people of color, but that's a chicken and egg issue because you got to hire them in the first place. So what do you do? And how does this relate to today's topic? Well, in my hypo, I talk about this in terms of salary negotiation, but it does involve employer responses, being aware of these issues, making sure that the people who are doing the negotiations do seek to minimize these stereotypes and make sure that information that is shared is the same information with everyone they negotiate. And then have diverse mediation. So that's my last suggestion, have diverse mediation. And what do I mean by diverse mediation? You need to make sure that the pool of neutrals is diverse. It's hard to get data on this. I tried. These private private three-party agencies that provide these neutrals, a lot of times it's hard to get the data. But most arbitrators, mediators, don't tend to be people of color. So you have to get around that system to make sure that you have a sufficient cadre or pool of mediators of color so that when the people that are involved in the dispute who don't have any voice, at least feel comfortable enough that maybe someone there who understands and can provide voice. I'm not talking about having racial preferences though. Just because someone is the same race doesn't mean they would have the same voice. I mean, Clarence Thomas is much different than Thurgood Marshall. So you just need to know that the system has those opportunities. Hold them accountable. All right, so that's pretty much what I'm gonna leave. I know a little bit later, so I'm gonna give you a chance to address any questions, if anyone has any questions.
I have one.
Yes.
Is this an American situation or is this worldwide? Are we just looking at America and how things you're talking about is just?
Yeah. I mean, I think there are some complexities regarding race that are not just in the US. Most of the things that I've been looking at though have been focused on the US.
Sure, that's what we're
But
at.
I think there are complexities regarding race and how we deal with race that are beyond just the US. I just haven't expanded into that realm in terms of what I've been looking at. I've been focused on the U.S. dispute resolution system.
Sure.
Right? So looking at the statutory mechanisms we have in place to deal with racial discrimination, and then looking at the defenses and arguments that people put in place to try and respond to, and trying to find a way, right, some kind of pragmatic solution that kind of figures out a way in which employers and employees can be better in trying to resolve these things. Yeah. Mm-hmm.
So can you tell me more about that? Did you just mean that with remediation, you're talking about a social process?
So yeah, I meant more where the mediation involved having a significant critical mass of mediators of color, so that the people entering into the system felt like it was a system where it was fair and not a one-sided system based on race.
Do you think the mediators would come outside of the organization?
They don't have to, but it would require a lot of hiring on the part of the organization internally to do it. You could use ombudsman too for that role, but you just have to hire a lot of them so that people could see from the pool. And with mediation, since mediation, you don't have to reach agreement, I really believe in providing as much process as possible, so that even if you go into mediation and you don't get a resolution, that doesn't mean you can't go and try another mediation with another mediator. As long as you have those opportunities to give voice, because that's really what I was starting off saying, most of these issues have involved complaints. A complaint, some kind of racial harassment, something has happened. And the responses have been to complain about the people making complaints, rather than trying to find some amicable way to resolve the disputes. And so I'm hoping that a mechanism where the institution's response to that is to jump right in. Now, there was talks about having top leadership. You gotta have top leadership involved in the beginning. You have to walk it and talk it. And if we're gonna use mediation, you have to have people, the neutrals have to have those skills to understand the complexities of these kinds of disputes. And the individuals involved have to believe that that process of selecting the mediator is one that is a fair one, providing many opportunities for people who may look like them and understand them. So that's what I meant by the special mediation. Yeah.
I've tried to figure out whether mediation or litigation is more equitable in terms of outcomes. Turns out to be a really hard question.
Yeah.
The negotiation studies that bounds very much on mediation.
It's comparing mediation versus litigation. Yeah, man, there's a lot of stuff about arbitration versus litigation, but mediation is even more difficult because it's an even more private process, right? With the hope that you end up with a settlement. So I actually wonder if it's, I have seen, I think there's a study, I want to say by Lamont Stallworth and Arut Varma, where they looked at, he had his own private dispute resolution system in Chicago, and he compared disputes there with what the litigation outcomes would be with people who chose not to use it. Very limited study. But with mediation, at least, there are those, what I call intrinsic benefits that you don't usually get from the litigation process in terms of voice, right? You at least get to tell your story to someone else in the process. And litigation, you may not. And then with those results about litigation, you still have those results that, but ultimately, so if I'm in litigation, I'm using this basic negotiation test, like what's my worst alternative to this agreement? And I'm going, well, if I go to litigation, that alternative sounds like a worst alternative too. That sounds like a zero probably. And so if mediation is out there and I get a zero, I still end up with the same result, maybe in terms of money, but but I get voice. Right? I have that procedural process to at least have been able to tell someone my story that I don't get necessarily the litigation part. And by when I was talking about 90%, most of that is through the summary judgment process. So maybe you get a deposition, but usually that deposition, the employers were running that deposition and they've controlled it. You're not getting voice. So with mediation, there's more voice. So, but that's a good question in terms of comparing. It would be wonderful. In fact, I want to say on the record, I'm not an empiricist. I love empiricists, though. I love to use their data. So I'm looking forward to whatever kind of data set you create so I can cite it. Yeah. So I'm looking forward to it. Okay. One more question. Yes.
Yeah, one of the things we talked about in our mediation class is the pros and cons of choosing mediation or choosing litigation over mediation. One of the pros is setting a precedent, whereas mediation you don't set a precedent, and balancing out where it seems like someone isn't breaking the law by saying that,
Yeah.
but that's balancing out that stability and yeah, mediation does seem like a good way to go, but on the other hand, it's that at the expense of setting a precedent in which implicit bias and the other things that we've been talking about today are not covered and decisions being made.
Well, so I agree, right? That's one of the criticisms of ADR, right? It's an informal system. And so there may be some need to have a public resolution. Right? There are going to be some instances where you need to have a public resolution. And I had it on one of those problems, I kind of skipped through real quick. But like, you know, I mean, Brown versus Board be Brown versus Board if it was resolved through mediation. So there's some instances where you need that. And I wrote an article about 10 years ago about the value of mediation in employment disputes. And to me, mediation is really about party autonomy. So even if that's the case, if that's what my client wanted, or that's what the employee wants, they want to try to set a precedent. As long as they're informed when they go through the mediation process. And what may be of value to them is at least having to be able to tell their story to the mediator. Remember, they don't have to reach agreement. So they can still do that. They go through the mediation process and they believe this is too important an issue. This needs to be resolved publicly. They can still bring their lawsuit.
You're suggesting to give the actual person themselves the choice whether or not they're going to.
Oh, I absolutely believe mediation should be about, well, informed, right? So that's one of the problems I talked about, like not having lawyers involved in the dispute. And I skipped over one slide where Halliburton uses this system. I don't know if that was you. I saw somebody women's when I said Halliburton. YouTube, it was not me. But Halliburton uses this system where they basically, in their ADR program, they basically allow for the employees to have legal services. So it's like a benefit they provide where an employee can then, like a legal services plan almost, and then get an attorney to represent them in the ADR process. And I think that might be helpful as long as it's a fair process, as opposed to no attorney. And so then it's an informed, right, decision. In that article I talked about what I wrote, I use a hypothetical where the mediator is like this really evaluative mediator, and they're telling this employee, you've got a great case, you can't settle this, this is terrible. And the employee says, I just want peace. I just want this to end. I just want them to say just one little word of apology and I move on. And the mediator doesn't want to settle. That's not party autonomy, right? That's not what mediation should be about. It's not the mediator's issue, it's the party's issue. So that's what the parties want. And it's informed, right? Informed, you've got a great case, you can win a lot of money. I just want peace, right? I don't want money. I just want apologies, I can go back to work. then that's part of your term. So that's my point. All right, thank you.